Good afternoon. Welcome to the second part of our program, Panel 2, Safeguarding Human Rights in Criminal Proceedings for Atrocity Crimes, Fitness to Stand Trial, and Counsel's Representation. The panelists, Judge Aminata Lois Runeni Ngam, Judge International Residual Mechanism for Criminal Tribunals. Judge Ian Bonomi, Judge International Residual Mechanism for Criminal Tribunals. Ms. Kate Gibson, Counsel before the International Residual Mechanism for Criminal Tribunals and the International Criminal Court. Professor Simeon Sungi, Associate Professor of Criminal Justice, United States International University, Africa. The moderator, Mr. Ian Edwards, Counsel before the International Residual Mechanism for Criminal Tribunals, International Criminal Court, and Kosovo Specialist Chambers. Welcome, Ian. The floor is yours.
Well, good afternoon, everyone. I hope you all enjoyed a delicious lunch. This second panel will pick up from this morning's panel in examining the importance of safeguarding the rights of accused persons in proceedings for atrocity crimes, focusing on two critical issues: fitness to stand trial, and the right to adequate legal representation. These are issues that are very often dealt with at the very earliest stages of proceedings, but they can manifest or re-manifest at almost any stage of a trial. It is unfortunately a reality that in international criminal jurisdictions, much time can pass between the alleged perpetration of offences and the arrest of alleged perpetrators, and they're being brought to court. And a very good recent example is that of Felicien Kabuga. He was arrested in 2020 at the age of 85, some 26 years after the Rwandan genocide. So during that time, the physical and mental health of alleged perpetrators can deteriorate as they age. So in the Kabuga case, for example, the trial chamber, presided over by our second panelist, accepted early on in the proceedings that he suffered from cognitive impairment and was in a vulnerable and fragile state. But where does age-related cognitive impairment and fragility cross into the territory of unfitness to stand trial? How do courts and tribunals resolve these difficult questions, often when confronted with conflicting and complex medical evidence? And how are accused persons' human rights protected in that process? Another essential aspect of fair trial proceedings is the right to be represented by qualified counsel, and indeed, the flip side to that, the right not to be legally represented. What happens when a defendant loses confidence in his or her counsel? What are the implications of ensuring that the right to counsel of one's choosing can be given practical effect? So these are the subjects that will be the subject of this panel. They'll be tackled by the illustrious members before you over the course of the next 90 minutes or so. Although I'm sure all are very well known to you, I will start with brief introductions, if I may. Immediately to my left, Judge Aminata Lois Runeni Ngum has served as a judge in the Gambia since 1980. She was a senior and principal magistrate for 10 years before being appointed Master of the Supreme Court and then first Judicial Secretary. Judge Ngum worked at the ICTR in a number of senior positions between 1999 and 2009, both in Arusha and in The Hague. She was then appointed as Judge of the Court of Appeal and the Supreme Court of the Gambia between 2010 and 2011. Judge Ngum came back to international criminal law and has been a judge of this mechanism since it commenced its operations in July 2012. Judge Ngum, welcome. It's an honor to have you on this panel. Educated in Scotland, Judge Ian Bonamy was from 1968 successively a solicitor, an advocate, Queen's Counsel, Judge of the Supreme Courts of Scotland, Judge of the ICTY, Judge of the Court of Appeal in Scotland, and Judge of the Mechanism. He's currently presiding judge in the now indefinitely stayed proceedings of Felicia Kabuga, although I believe there remains a significant amount of work for you and your colleagues to do in the case. In 2020, Lord Bonamy served as a member of the group of independent experts which reviewed the ICC and provided recommendations to improve that court's performance. And to top off these many achievements, he is sensible enough to spell his name the correct way. It's a pleasure to welcome you, Lord Bonamy. I now turn to my excellent friend and partner in crime, Ms. Kate Gibson. Kate has been appearing for the defense before the international courts and tribunals since 2005, including as co-counsel in the cases of Jean-Pierre Bemba and Bosco Taganda at the ICC, Radovan Karadzic at the Mechanism, and the former Liberian President Charles Taylor before the Special Court for Sierra Leone. Here in Arusha, she appeared in 3 cases at the ICTR, including as lead counsel for former Minister Justin Mugenzi. And Kate is currently on the defense team for President Hashim Thachi before the Kosovo Specialist Chambers. Kate commands the deep respect of judges and defense and prosecution colleagues alike, although I suspect that respect from her OTP opponents is often adulterated with a certain amount of terror. Kate Gibson, welcome to you. Lastly, and by no means least, Professor Simeon Sungi, a late substitution from the bench. Professor Sungi is an associate professor of criminal justice at the United States International University in Nairobi. He's also an advocate of the High Courts of both Kenya and Tanzania, and a former staff member of the ICTR. He was awarded his PhD in criminal justice from Indiana University, and before that, his master's degree in criminology and criminal justice from Indiana State University. He has published widely in both local and international journals and is the editor-in-chief of the Africa Journal of Crime and Justice. Karibu sana, Professor Sungi, and thank you very much for agreeing to join us at such short notice. Right, well, that now out of the way, let's move on to the questions, and if I may, I'll start with you, Judge Ngum. What is the correct legal standard in international criminal law for the determination of fitness to stand trial? Practically, what are the challenges that commonly face the parties in adducing evidence of whether an accused person is or is not fit to stand trial?
I would like to start by giving a definition of atrocity crimes, which are a violation of international criminal law that falls under the historically 4 legally defined international crimes of genocide, war crimes, crimes against humanity, and ethnic cleansing. Now, when you started, you were talking about the age of the accused persons in atrocity crimes. Now, in the Gambia, there are allegations that atrocity crimes were committed during the 22 years or as found by the Truth and Reconciliation and Reparations Commission, and the recommended prosecution of some of the alleged perpetrators. But you find that those are much younger perpetrators, some of them 50 years plus. However, the country's limited human and financial resources are challenges for bringing those perpetrators to justice. But the TRRC highlighted that the Gambia ratified the Rome Statute in 2004 and is a state party to the ICC. So we would expect that something will take place, although there are also some discussions that there may be regional representation at the West African Court of Human Rights, but we are not quite sure what is going to happen, you know. But there has been universal jurisdiction also in some of those cases that I mentioned, and it was mentioned that in another case, one of the accused person called Usman Sonko, who was actually tried in Switzerland. He was 55 years old, was 7 years in pre-trial remand custody, and the conditions of his detention, the lawyer was complaining that this gave him physical and mental health problems because he was a diabetic and he had been held in solitary confinement without much light. And although when asked, the lawyer stated that he was not going to request for a fitness and unfit to stand trial, and said that the accused person was fit to stand trial and he was tried. So that is a case that I wanted to bring to their attention. But on the international scene, the ICTY, in the case of Prosecutor versus Pavle Struga, the appeals chamber there stated that the prejudice to the accused person resulting from continuing the trial while he or she is unfit to stand trial would amount to a miscarriage of justice. So the appeals chamber there gave a non-exhaustive list of the capacities for trial chambers to consider whilst they are making fitness determinations, which include 1, the ability to plead, 2, the ability to understand the nature of the charges, 3, the ability to understand the course of the proceedings, 4, the ability to understand the details of the evidence, 5, the ability to instruct counsel, and 6, the ability to understand the consequences of the proceedings, and 7, the ability to testify. So this means that they expected there to be meaningful participation by the accused person, despite the fact that he may be represented by counsel. He himself should personally be able to participate meaningfully in the proceedings. We had similar issues in the case of Prosecutor versus Ratko Mladic, in which the accused person from time to time they would bring issues of his health to the court. In fact, we nearly thought we were not going to have a hearing of the proceedings by video link because of the different health, confidential health situations that were being produced before the appeals chamber. But in the end, the appeals chamber held that the defense counsel had not substantiated that Mladic is unable to communicate, consult with his counsel, and/or understand the essentials of the proceedings. So we proceeded with the hearing of the appeal, and we proceeded in delivering judgment. And despite all what they were saying, Mladic is still alive. The next case that I was involved in is the Kabuga appeal. In the Kabuga appeal, I will leave Judge Bonomi to say more about it. I'll just discuss a little bit about what my participation in that appeal. In that appeal, the appeals chamber decided that the accused person was not fit to stand trial, and therefore the case should be sent back to the trial chamber for them to deal with it. And Judge Bonomi will continue with that. The other case that I dealt with also, where unfitness to stand trial was also produced at an earlier stage, not during the appeal, but was in the prosecutor versus Stanisic and Simatovic case, in which the accused person also, because of his age, had health situations. And when you look back to the to his trial, because he had a trial, then there was an appeal, then the appeal was appealed against, and it was decided that the case goes back for trial. So it went back for trial, and then came to us on appeal. So it had taken over 20 years whilst they were up and down. And I read one of the decisions where the court actually held that the accused person should be allowed to go and have his health sorted out. I think it took about 6 to 9 months while the court could not sit because of his health situation. And even when the case was on appeal, he was not coming to court. He was appearing through video link, but his counsel was appearing, and the junior to the counsel were appearing. So unfitness to stand trial can be a challenge for elderly accused persons. Thank you.
Thank you very much, Judge Ngum, for 2 reasons. First, for your very clear exposition of the principles surrounding fitness to plead, and for illustrating your points by reference to specific cases and your own experience in Mladic and Stanisic, for example. And secondly, thank you for sticking to time. That was almost exactly 10 minutes. Let me now then turn to Judge Ian Bonomi. What are the options, Judge Bonomi, open to a chamber following a positive finding of unfitness? To what extent does the very nature of international crimes impact on the decision-making process in deciding what the consequences of an unfitness finding should be? So what I mean is, should broader public interest considerations be at play in any way whatsoever when dealing with atrocity crimes?
Thank you very much, Mr. Moderator. Good afternoon, everyone. I have a very bad record of having been a member of 2 trial chambers now that were unable to complete their cases. So I've had a lot of time to think about this sort of situation. And when I was invited to participate in this panel on this subject, I went back to basics and had another good look at it, but informed by previous experience. So these are simply my reflections on what is a very difficult situation. The case of Kabuga before the MICT is simply the latest in quite a long line of cases where the accused has faced the gravest of criminal charges, but been found unfit for trial, resulting in the proceedings being brought prematurely to an end. And I want to answer the questions put in a very general way, first of all, and then move on from that. The following propositions, I think, are basically sound. There's currently no appropriate procedure in international criminal law to bring to a decisive conclusion a case where an accused has been found to be permanently unfit to stand trial. Most international courts simply provide for a trial to be adjourned. The second proposition is that this is going to be an ongoing problem because of age, and that's been dealt with by both speakers so far. And the third proposition is, when a case involving permanent unfitness arises, there can be no doubt that the issue needs to be considered and resolved in line with applicable human rights protections. But in that regard, there is a new kid on the block, and that is the Convention on the Rights of Persons with Disabilities. And the Kabuga case, I think, is probably the first international case which has gone into that subject in detail. Now, can I say a little about the historical context? The issue of fitness has arisen in almost every international court, going back to the International Military Tribunal in Nuremberg and also the Tokyo Tribunal. It's arisen in the ICC and other courts. Indeed, at the ICC, the issue has arisen already in 5 cases where there have been hearings and decisions. But in every one of these hearings, the accused has been found to be fit. So they don't have any jurisprudence in relation to what happens if that's not the result. The existing legal framework before the ad hoc tribunals and the mechanism is purely and simply a provision about medical examination being possible and appropriate in certain circumstances. The fitness determination that might arise as a result follows, as you've already heard from Judge Ngum, the decision. It's a case law basis for what happens then, and that's the case of Strugar. The Strugar test is well known, and this institution continues to apply it without question. Before other international courts, the situation is almost the same in all of them, but the ICC has one provision in its rules which allows the court to adjourn if an accused is found to be unfit. There's nothing said about what should be done, and only it permits medical examination, but there's nothing said about what should be done if the accused is then found to be unfit. And I believe the rules of the Special Court of Sierra Leone and the Kosovo Specialist Chambers also envisage the possibility of ordering a medical examination of the accused and adjourning the proceedings. So that seems to be as much jurisprudence as there is. So moving on to address the consequences of unfitness in more detail, a survey of the rules and practice established at the international and domestic level show that courts have historically favoured the suspension of hearings in cases of unfitness, while also continuing to exercise jurisdiction over an unfit accused. So he's trapped, essentially. The court has decided that it will maintain jurisdiction just in case, the question of unfitness just rests as a reason for him being where he is. Suspending proceedings for a definite or indefinite time has been used, even back as far as Nuremberg, but nothing really has changed in international law and, generally speaking, also in domestic law. Slightly surprising to me was the finding that international courts have generally refused to adopt the exceptional remedy of terminating the proceedings. But one never knows, that may change. Now, the challenges raised by indefinite stays rather than terminating, I think, should be considered carefully. During the indefinite stay of proceedings on account of unfitness, accused are often held in custody, or if released, they are subject to restrictive regimes, including monitoring. Is suspending proceedings in these circumstances in conformity with human rights? That's a question that I cannot answer today, other than to say on the face of it, it looks as though it may not. The right to the presumption of innocence and freedom from arbitrary detention, as guaranteed under the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, is that indefinite stay consistent with these provisions? Again, I doubt it. And the right to equal access to justice for persons with disabilities, and the right not to be deprived of liberty, either unlawfully or arbitrarily, as guaranteed under the new kid on the block, under the Convention on the Rights of People with Disabilities. Is indefinite stay consistent with that? I doubt it. Now, just turning briefly to that convention, I could say a great deal about it, but the important things are these. It was adopted, adopted in 2006 and entered into force in 2008 and has been ratified by 186 states parties. And we are United Nations body ourselves, generally speaking, able to give full recognition to UN conventions. It doesn't in itself include any standards on fitness or consequences of unfitness, but it sets forth general rights for persons with disabilities. For example, it requires states parties to ensure effective access to justice for persons with disabilities, which means adjusting the proceedings in what could be a very large number of ways to accommodate such an accused. And Article 14 underscores that persons with disabilities on an equal basis with others shall enjoy an equal right to liberty and security of person and not be deprived of their liberty unlawfully or arbitrarily. The essence of that article is that you must do what is necessary to ensure a trial can be completed, and failure to do that is a failure to recognize the normal legal capacity that we all possess and that disabled people possess in equal measure to everyone who is fully fit. In that area, there is a great deal to be said, but I confine myself to this. I think there is a measure of urgency involved for all international tribunals to consider establishing as far as they can, and this is going to be a long process if it's ever going to be fully realized, to establish as much as they can in the way of special measures to ensure that the accused can overcome the disability that he faces and have his case considered and have his say, if possible. There have been many situations of serious injustice highlighted in the reports of the committee that oversees the operation of the convention. Many of them in Australia, for example, where there are cases of accused people being held in custody for periods of 5 years, when the maximum sentence would have been 12 months imprisonment. Now, it's stating the obvious just to say that that can't possibly be right. There must be a method for that person to be able to have the case against him examined expeditiously. And if it turns out that his medical condition requires special arrangements, so be it. But you then have a proper basis on which to make a decision about where these arrangements should be established. Now,
Can I just interrupt you for a moment, please?
Yeah.
Because Professor Sungi is going to talk a little bit more about considerations relating to disability discrimination.
Yeah.
I wonder if in just a minute or two, if you could just give us a sense of the trial chamber's thought processes when deciding on the Kabuga situation.
Now you're getting close to the bone.
Coming back to the question, to what extent did the nature of the charges that he faced play on your ultimate decision?
Yeah, it was your second question. And the answer to that is none. The charges are there's nothing particular about the charges that would make it easier or more difficult to arrange a trial having regard to the disabilities faced by him. And there is no mechanism standing the Struga jurisprudence for going, as it turns out. We did our best to devise a method, but we found no way round the obstacle of unfitness. I was just going to finish, and I'll be very quick on this, and I might get a chance to say some more. At the end of the when the trial proceedings were stalled, I accidentally came across a case in England. The last place on earth a Scotsman would normally look for such authority. And this case was about computer hacking on a large scale. And the two accused were both teenagers. One of them was found to be unfit for a trial because of he was autistic. And the other was fit, but was not an adult, in fact, was a youth. The trial proceeded, it was in the Crown Court in Southwark, and it proceeded against both of them during last summer on exactly the same proceedings. And at the end of these proceedings, the jury, which had to make the decision, was directed that for the one who was autistic, they could only establish whether it was proved beyond reasonable doubt that he did the acts alleged or made the omissions alleged, which constitute the crime. And if he didn't, they would be acquitted. And if he did, they would make a finding to that effect. For the other accused who was fit, he was simply given the usual directions. If it is proved beyond reasonable doubt, you'll find him guilty. And if not, you will acquit him. Now, I simply refer to that as an example of how the process we put together in the Kabuga trial for going a stage further, because as you know, our decision at that time was that we could in fact adapt the procedure to suit the circumstances. That would have been the sort of adaptation that we would have adopted.
Thank you very much.
And if I've missed anything about your second question and the significance of the charges, you can maybe prompt me later and I'll try and answer it. But I don't at the moment see the relevance of that.
Yes, okay, we may come back to that. I mean, alternative solutions in the way of, for example, a trial on the facts is something that the prosecution in Kabuga pushed very, very hard for. Maybe we'll come back to it in a moment, but it seems to me that in international cases, especially genocide, where the gravamen of the offense is the mens rea, is the intent of the perpetrator. I wonder whether that makes a classic English-style finding of the fact process entirely applicable. But perhaps we can come back to that later.
Okay.
Ms. Kate Gibson. So Judge Bonomi a moment ago referred to courts being faced with a situation where the defendant stays where he is, the court maintaining jurisdiction. What challenges exist for those in charge of the management of international courts and tribunals and the defense counsel when former accused persons can no longer be detained because they have been found unfit? And of course, the same question can be asked in the context where a court maintains jurisdiction over persons who can no longer be detained because, for example, the prosecution has withdrawn the charges, Ockham, for example, or once a defendant has been acquitted or has finished serving their sentences. So in other words, what can the court do when defendants are in this limbo situation? And to what extent is this a political or diplomatic problem as opposed to a legal problem?
Thank you very much for the question. I just want to start quickly by thanking the organisers who've done such a great job of putting this event on, in particular to the President, Gatti Santana, for having invited us all here to be part of this really important event. And your question is an important one. You know, what are the challenges that arise essentially when an international criminal case does not end with a conviction and a life sentence? You know, where former suspects or accused are acquitted, or where they're found unfit, or where they've served their sentences and need to be released. And sometimes there's no challenge here at all. We saw regularly at the ICTY that former defendants were willing and able to return to states in the former Yugoslavia and assimilate successfully back into society. But it's not always the case that defendants will be able to return home. And we've now seen at the ICC, for example, former defendants from the Central African Republic and from the Democratic Republic of the Congo who think that they can't safely return home despite assurances from the governments in question that they can. And I think this is where the challenges start. Because we've seen, even with this sort of re-emergence or renaissance of state support for international criminal justice in the last few years, many states don't see their role in supporting the International Criminal Justice Project as extending to things like facilitating provisional release of accused or giving a home to former defendants or suspects. And many states see their role more as supporting the front end of international criminal justice. So the investigations, the prosecution, the arrests and surrenders, and not really at the back end of the cases, particularly when things don't go as hoped or planned. But this is where former defendants really do need assistance from states if they're going to have any chance of a dignified life after their engagement with the court ends. But that hasn't happened yet. Many states don't see their role as supporters of ICL as extending that far. And this certainly isn't a problem that's unique to the Kabuga case. It's not unique to the mechanism. You know, we had situations in The Hague where former accused were left in legal limbo for months, and in the case of Mathieu Ngajolo, years after having been released by the ICC, but not permitted to remain in the territory of the Netherlands, but then being unwilling to return home. And, you know, the most prominent example of this is the 7 former ICTR defendants, who, the previously 8 and now 7, who have been illegally detained in Niger since December 2021. And Ian, both you and I have clients in that house, so we have a sort of daily insight, if you like, into how difficult that situation is. And even when you have this reality where you have former defendants, some of whom have been acquitted, are going to remain indefinitely and illegally detained, we still don't see states being moved to see it as part of their role to step up and intervene. And that's the challenge. You know, that's the problem that we have. You ask whether it's a political and diplomatic challenge or is it more of a legal challenge. I think we've seen after litigating these issues now for over a decade that the position of the mechanism is that this is a problem that needs a diplomatic solution. You know, so how can we do that constructively? How do we find meaningful diplomatic solutions to these problems? And we've all spent a lot of time in this field as defense counsel, as prosecutors, as victims reps, discussing, you know, why this challenge exists and why it is so difficult to advocate on behalf of this category of people, being former defendants, and allow them to have some sort of legal existence once they're at the end of this process. And one of the things we often discuss is the need to engage with states about what the role of international criminal courts really is. You know, that the goal of international justice isn't necessarily convictions and long sentences. The goal of international justice is fair trials. And, you know, as we all know, we're all lawyers, a fair trial is an exercise that can have one of two equally legitimate outcomes, you know, convictions or acquittals, and that trials which end without convictions or trials that end in acquittals aren't necessarily something having gone wrong at the level of international criminal justice. And so I think that's an obligation on all of us in this field to engage with states to try and change this mindset and demonstrate that support for ICL can't be selective. It can't just be directed towards investigation and prosecution and arrests, that it has to include the whole picture, which includes assistance for people who fall outside that category. Otherwise, the system doesn't work. And I'll stop there. You know, I think it's obvious I could talk about this all the livelong day, but I'll just say that, you know, for so many of us, it was such a privilege to spend so many years of our youth and careers here in Arusha. You know, I was here for 6 years, and because I believed and continue to believe in the importance of the work that the tribunal was doing in ensuring accountability for all the reasons that our keynote speakers set out this morning. And so it's problematic if our story as a tribunal ends with people who are acquitted being indefinitely detained. You know, that's problematic to us as a group of sort of human rights oriented lawyers who really believe in the principles of fair trials and presumptions of innocence. So that's why we keep talking about this issue, even if it's just to make sure that better processes are put in place in future criminal tribunals.
Thank you, Kate. As a moderator, I'm supposed to be scrupulously neutral, but for what it's worth, I think you've put your finger on exactly the issue. States are far more interested in the front end, the arrest, the investigation, the arrest, the prosecution. If things go well after a fair trial, conviction, and states will be very happy to accommodate convicted people in their prisons. And there's a huge amount of cooperation on that side of things, but it's almost as if states kind of sort of shuffle away a little bit and bow their heads and wander off when things have not gone right, and you're faced with an acquitted or somebody who's served their sentences. Professor Simeon Sungi, Judge Bonmi touched on it, this issue of disability discrimination. What do international norms, so I'd like you to pick up on that, please. What do international norms relating to the rights of persons with disabilities say about accused persons who are or who may be unfit to stand trial? And if you've got anything to say about circumstances where, you know, for example, in a genocide trial, where the whole issue is going to turn on the mental element of genocide, or a large part of it is going to. And how can we deal with that when a person is found unfit?
Thank you, Ian. I also want to thank the mechanism for putting this colloquium together. Madam President, thank you for the invitation. I'm Tanzanian, so the mechanism brought me home, so to say. And also I've seen very many old friends, some who were my role models as a young Tanzanian. In this field, we looked at Judge Sekule as the Moses, so to say, and it's kind of a little bit intimidating to speak before judges, but I'll try to do my best here. So I think the law is settled as far as the right, the fitness to stand trial of accused persons. And really it's the cornerstone of any legal system because it ensures that the individuals who are accused of crimes can really understand the charges against them and participate effectively in their defense. So this is really a fundamental right. And I did some little research when Ian suggested what I should probably talk about. And I looked at some few cases from a jurisdiction called Australia, and we have a few Australians here in the panel. And for example, and they have really developed jurisprudence in this field. For example, in the Eastman versus DPP case, this is a 2003 case, Haydon J. held that the rule preventing an accused person from being tried unless fit to plead is among the key rules of criminal procedure, which seek to ensure that a successful prosecution case rests on reliable evidence. If accused is not fit to plead to stand trial, there can be no trial. And in the same case, another judge concurred with Hayden. His name is Gordon, and he said, if a person stands trial, notwithstanding that there is an unresolved issue as to his or her fitness to plead, or if that issue is not determined, the manner which the law requires, no proper trial has taken place, and the trial is a nullity. So clearly, you can see here that the law is settled, in my view, in this area. So what are the sources here? We talked about this a lot, the Universal Declaration of Human Rights, specifically Article 10 and 11. So Article 10 of the UDHR speaks about right to a fair and public hearing. Article 11 speaks about that everyone charged with a penal offense has the right to be presumed innocent until proven guilty. The ICCPR, the International Covenant on Civil and Political Rights, Article 14, which provides guarantees relating to the right to fair trial. Though the ICCPR does not speak explicitly about fitness to stand trial. So the general provision, Article 14, is relevant. The convention, the judge spoke about it, the Convention on the Rights of Persons with Disability, and I think Article 13 of the CRPD is to me the backbone of the convention, which recognizes the right of the person with disability to access to justice on an equal basis with others, including through effective accommodation to ensure their effective participation in legal proceedings. But also Article 13.1, which says that state parties shall ensure effective access to justice for persons with disability on equal basis with others, including through the provision of procedural age-appropriate accommodations, and I kind of underline that. including through the provision of procedural and age-appropriate accommodations. But we also have the principles and guidelines for the protection of persons with mental illness and the improvement of mental health care, which is also known as the MI principles. So the MI principles were adopted by the UN General Assembly and provides guidance on the protection of the rights of persons with mental illness, including those involved in criminal proceedings. Principle 18 of the principles, of the MI principles, emphasizes on the importance of ensuring that persons with mental illness who are involved in criminal proceedings receive a fair trial and have access to legal assistance and representation. Other sources, obviously, would be the jurisprudence of courts from different jurisdictions, but also the international tribunals. And in reference is the Kabuga case in our discussion. Now, again in Australia, there was a case decided in 2016. It's called Marlon Noble versus Australia. And in this case, the UN Committee on the Rights of Persons with Disability held that Australia was in violations of a series of obligations under the UN Convention on the Rights of Persons with Disability. And so, again, as I stated, I think the law is settled here on the issue. Now, a brief facts of Marlon's case. So Marlon was an indigenous man from Northern Territory of Australia. He had a cognitive impairment, which was caused by meningitis during his infancy. This is an individual, this is a defendant who had a disability from the beginning. Yeah. When he was 19 years old, he was charged with 2 counts of sexual penetration of a child under 13 years and 3 counts of indecent dealing with the child between the ages of 13 to 16, which was contrary to sections 320 and 321 of the Western Australia Criminal Code of 1913. So to me, I think this distinguishes, the Marlon case distinguishes the Kabuga case in the fact that here we have a defendant who evaded justice for almost 30 years, uses his power, money, and influence to evade justice. And after 30 years, he is detained and he's found to be unfit to stand trial. So I think it raises very serious issues relating to justice and to me, in essence, what is the purpose of international criminal justice? I think, in my view, it sends a terrible message that one can evade justice for as long as you can, but when you are captured and detained, and I'm 100 years old, then I will go home scot-free. So I think, to me, it raises some serious questions. Ian?
Thank you very much. We don't have, I think we started a little bit late, so we're running against the clock. I had some further questions for the panel to deal specifically with the second topic, the right to legal representation. But I think the panelists are going to have to do their very best, please, to answer in shorter than 10 minutes, because we are against the clock. But I'm going to come back to Judge Ngum. How do international courts and tribunals ensure that defense counsel are sufficiently experienced and competent in order to be assigned to represent persons accused of the very gravest crimes?
Thank you. I think here I'll bring in my experience at the Defense Counsel and Detention Management section when I was a legal officer there. What we used to do was that when an accused person is arrested, then the registrar would assign a counsel who will deal with the case until a lead counsel is appointed. What happened was that the Defense Counsel and Detention Management Section had a list of counsel who were eligible to appear before the ICTR, and I'm sure ICTY had a similar case, and the same with the mechanism now. So it is from that list, you give the list to the accused person, and then the accused person will decide who he would want to represent him as his lead counsel. What we did was we would check when somebody applies to go on the list of defense counsel eligible to appear before the ICTR, we would check with the bar association of that applicant and confirm that he indeed is qualified to practice in his own country or her own country, and also whether the person has the other requisite qualifications. And then for lead counsel, it would be the registrar who would make the recommendation, and we used to prepare what was called a Rule 33B submission. I'm sure it's still the same today. And that would be prepared by the deputy registrar, go to the registrar, and then go to the judges of the trial chamber or the pre-trial judge if the matter hasn't gone before a trial chamber yet. And once the registrar makes a recommendation, we used to have no problem with the trial chamber accepting the recommendation made by the registrar. We had other issues where in the middle of the trial, the accused person would decide he doesn't want his lead counsel anymore, and then we would have to make the same the same system to try and get him a new lead counsel. However, it was the lead counsel who would then choose his co-counsel from the list. So it was not the accused person who chose the co-counsel. The co-counsel was chosen by the lead counsel. And then he was entitled to choose 2 other legal officers. One would be a legal officer and one would be an investigator. Yes, so when they claimed their expenses, they would claim them according to lead counsel, co-counsel, legal officer, and legal assistant and investigator, like that.
Thank you very much for that foundational explanation. That's very important. Judge Bonomi, so much for accused getting lead counsel. But there are occasions, of course, when defendants want to represent themselves. They positively do not want legal representation. Does international criminal law recognize a right of self-representation? And if so, what limits are there on that right, specifically in long and complex trials, such as international criminal trials usually are?
Well, 3 of the most prominent accused to appear before the ICTY chose to represent themselves: Milosevic, Judicial, and Karadzic. And in my view, that was regularly a source of trouble and potential injustice. I don't think I'm disclosing anything I ought not to when I say that when Milosevic died, the trial chamber believed that we were not far from the end of the trial, but we had been troubled for some time during the presentation of it was easier in the prosecution case, but during the presentation of the defense case, by the illnesses that he was suffering and the absences that resulted, because of the workload, as we now know, and the state of health. And the trial chamber considered whether it could impose counsel. There was a view at that time that it was only through misbehaviour that a counsel would be imposed. But we persuaded ourselves that, in fact, that was far too narrow a construction of the statute. And we indeed decided that counsel should be imposed. Now, that was overturned, but when it was overturned by the appeals chamber, the rationale for the decision was accepted. So I think it is established now that the trial chamber can insist on representation. And we were blessed, in a sense, by the subsequent events and by the presence of Stephen Kay and Gillian Higgins, because they were subsequently appointed standby counsel and exercised, even in that role, certain activities in the conduct of the case. And undoubtedly, we made progress with that assistance, and we could have made more progress if counsel had been, or maybe not. I have no insight into counsel's head, so perhaps it would have been a fatal mistake. But we think that the appearance of justice in the end would have been more satisfactory. All of these counsel, and I've mentioned in general terms the way that proceedings can be disrupted, but the behaviour of both Judicial and Milosevic, to a far lesser extent, was undoubtedly disruptive and offensive to witnesses in some instances, in a way that it's very difficult to handle as a judge when you're dealing with an exposed accused who's not represented. You're walking on eggshells all the time in dealing with it. You're getting near the end of the case, and the last thing you want to do is derail it.
Yes, of course. I mean, in the case of a represented defendant, you know, the measure of last resort might be to say, right, well, leave the courtroom, go back to the detention centre. Your counsel will crack on in your absence, but you can't do that if it's the defendant representing.
Well, that remedy we didn't have. However, maybe someone can think about tomorrow whether you could remove the accused to cell and arrange communication, electronic communication, to keep them out of the face-to-face situation with witnesses, which that was a very disturbing feature, that the witnesses, victims of sexual offences, sexual assault, had particularly insensitive things put to them. And one double amputee was addressed at the end of the examination by Milosevic with the words, "Do you know the old Serbian proverb that people who lie have short legs?" And you can understand the situation in the court when that happened, and there was a reaction on that occasion.
And I think
so. It's a rule we need. We need the clarity and the circumstances in which counsel can be imposed.
And I think at the Kosovo Specialist Chambers, and Judge Gill will be able to correct me if I'm wrong, but I think things have moved on so that, in fact, Kate will be able to, that circle has been squared so that now constitutionally defendants must be represented. Right? Yeah. Kate Gibson, what rights do accused persons have in terms of their choice of counsel? And what can or should a chamber do when an accused person loses confidence in his or her counsel?
So does an accused have a right to counsel of their choice? Yes. Is that right completely unqualified in ICL? No. Her Honour Judge Ngum talked about a list of qualified counsel. An accused is required to choose a counsel from that list. In terms of how...
If they want that counsel to be paid for out of the public purse.
But then, regardless, there still are criteria that need to be met. Even if an accused has a truckload of money, they can't bring in someone unqualified and pay them out of their own pocket. But yes, that distinction exists. What's interesting is how far the different courts will go in terms of limiting that right to choose counsel. And I've certainly experienced a much more sort of arm's length approach to this at the ICC when compared to the ICTY and ICTR, where the registrar sort of more actively sought to ensure in the early days here in Arusha that defence teams were composed at least of a counsel from a civil law tradition and one from a common law tradition, so that the team would more easily be able to sort of absorb and function in the famously mixed procedure that we had here. And I found an early decision in Batare, so I'm looking at Judge Sekule, who will now forever be known as Moses, and he wrote that when the registrar was appointing accused for the 6 co-defendants, the registrar should take into consideration the geographical distribution of counsel and a balance of the principal legal systems of the world. And I think this was a response at the time to the over-representation of Canadians in the defence side, who'd been sort of widely appointed because they could work in English and French and they had already this civil and common law mix. So I was part of the Bagasora trial, and that was just, you know, Canadian central on the defence side. But at the ICC, I found that, you know, as long as the proposed defence team members can either get on the list of counsel or the list of legal assistants, the counsel support section is very reluctant to sort of interfere in that choice. But, you know, having said that just quickly, I think the teams that I've seen that have functioned most effectively are the teams that have been the most diverse. You know, I think it's madness to think that we as Australian lawyers or members of the Bar of England and Wales can effectively represent someone from the Central African Republic or from the Congo without working with lawyers or at least, you know, resource persons and investigators from the region who share a language with the accused, who can talk directly to victims and witnesses, who understand the background, the context, the politics, the conflict. They can tell you, you know, this is why this newspaper will say one thing and this radio station will say another. You know, without that backdrop, I think our job becomes a lot harder. So, you know, for me, the more international criminal justice is, the more chance it has at being effective. So that's building teams. That's the easy part. You know, what happens when that falls apart? And the question of withdrawal of counsel is a really sensitive one. You know, and again, it's one that happens quite frequently. We just saw in the main case of the Kosovo Specialist Chambers in the last month, lead counsel for the lead accused has withdrawn. It's the second lead counsel who's withdrawn in that case. And it's difficult because there are these competing factors to weigh, you know, one of which is this fundamental cornerstone right of an accused to choose his counsel. Another one is keeping these trials on the rails. Right? These are massive proceedings, millions of pages of disclosure, years of hearings. As a new counsel coming in, that's overwhelming and that's going to take time to read in, and that will lead to delay. So it's often the impetus of the court to try and keep the counsel in the case. And, you know, counsel are often in a difficult position too in those situations, because not only is practicing counsel we governed by the relevant code of conduct, but also we have our ethical obligations that still overhang us from our national bars, both of which will normally include an obligation not to in any way act in a way adverse to the interests of a current or a former client. So defence counsel can't just get up in front of the court and say, my client's lying to me, or, you know, my client wants me to appoint his nephew as the investigator. You know, is that in the interest of the client to say those sorts of things to the judges? Arguably not. So you see defence counsel sometimes having to walk a really fine line here, and that's why these requests for withdrawal are often, you know, quite circumspect. In terms of what is a good enough excuse for withdrawal of counsel, we now have a body of case law, and we can see that it oftentimes isn't enough for the accused just to say, I won't communicate with him anymore, or that we've had a breakdown of trust and confidence. You know, luckily I'm not a judge, so I don't have to make that call, but I will say that it's certainly something that counsel should have in mind before they sign up to these cases, that this is you know, in some cases a lifelong commitment, and that once you're in, it's very difficult to get out.
Absolutely. Thank you. And finally, come back to Professor Sungi. You have a special insight into indigenous justice mechanisms. So can you just speak for the next 5 minutes or so about what your study of these indigenous justice systems, specifically indigenous justice mechanisms in Africa, say about the right to legal representation, if anything?
Thank you, Ian. Well, I'm not sure whether indigenous justice systems provide specifically on the rights of an accused person per se, but the cornerstone, the backbone of indigenous justice systems is to allow reconciliation and allow the community as a whole to participate in resolving societal conflict. So this means then that obviously a person who is accused of crimes is afforded an opportunity to be heard. And but again, the participants are not just a few players, but the community at large. And so I think this case, the Kabuga case, for example, is a good candidate for such systems. In 2015, I think I wrote a book which was titled Dealing with International Crimes in Africa, When Are Indigenous Justice Systems Better Than Criminal Trials? And now this case is perhaps one of the best examples of how indigenous justice systems can play a role. Yes, Mr. Kabuga is presumed innocent, but they are real victims of the Rwanda genocide. I mean, this is not, and I think the decision of the appeals chamber, as far as Rwandese people are concerned and the victims, though when I read the ruling, I mean, there's a sentence or two where the court is saying they understand how this decision is going to be viewed by the victims. I think it's highly problematic. And I'm not trying to suggest here that these are simple questions, because they're not. They're very difficult questions. But I think behind all this is this overall question of quest for justice. And obviously in this case, there's clearly an injustice.
Thank you very much. It's a few minutes to 3, and as I said earlier, we started a little bit late. I'm looking for Fiona or Vanessa. Do we have time for 2 or 3 questions from the floor? Okay, excellent. Thank you, Vanessa. All right. Well, first of all, before we end, I just want to thank all panelists for their contributions. It's been a very rich discussion, and a great deal of very difficult issues have been raised. Can I invite the audience to ask any questions? Yes, Judge Aegis.
a question at a tangent. What would you do in a situation where, as the judge or as the presiding judge, all of a sudden come to the conclusion that defense counsel chosen by the accused, who adamantly wants to keep him, to retain him, is completely incompetent and mishandling the case, and obviously leading the accused case to a negative end? What do you do?
Judge Bonamy, would you like to start the ball rolling?
Well, I think that's a matter for the Bar Association. First of all, the ICCBA,
Yeah.
in relation to the ICC or the appropriate individual bar association for another court. And is there not a general bar association as well? A general international bar association? No, they're all specific to institutions.
Well, there is an international bar association, but it's more.
Oh yeah, that's a different thing. But there isn't. No, right. And secondly, I think that in the absence of action there, people who could see something going wrong would be likely to seek out advice from the home state of the council's bar association and alert them to what would be being done by someone that they recognize as a competent counsel to conduct. So I think it's some sort of whistleblowing exercise, but it can be properly investigated then by the bar administration, and he gets his chance to defend himself. I doubt if he could bring his client to defend him, but he would certainly. Yes, I understand that. But in that case, the client would possibly be prepared to write all sorts of glowing references for him. I can see that. But I don't think that would play out as a relevant consideration. But I do think that counsel, it would be appropriate to report that matter to the disciplinary body that governs his activities. And to the court might feel a responsibility, because otherwise they consider that there may be a miscarriage of justice.
Okay, if ineffective assistance of counsel is theoretically a good ground of appeal against conviction, is there not anything that the trial chamber can do if they can see plainly that the defendant is not being effectively assisted?
I mean, that's exactly what I was going to raise. That's the risk, is that upon conviction, the accused can turn around and say, I wasn't effectively represented. And if that's the case, then he hasn't been protected during the trial process. And I also think that this is an issue that the prosecution has to be invested in, because they want the trial proceedings to be fair. What a nightmare for the prosecution if they've secured a conviction and it can get unstitched because everyone knew that defense counsel wasn't doing their job. So there needs to be intervention, because there has to be an effective balancing of these rights, the right to choose, but then the right overall, an overarching role of the trial chamber to ensure that the proceedings are fair. And that overarching role is articulated in all the statutes. And I think perhaps a trial chamber could hang a decision on that obligation. But obviously this is theoretical, because defense counsel at the International Criminal Courts are top notch. But it's good to talk in hypotheticals.
Thank you. We've been told to wrap it up. I think what really has come out. Oh, one more question? Oh, okay. Okay, yes. Well, apparently not. I misspoke. There's one more.
Very kind of you. Thank you very much, and the panelists for your patience. My name is Charles Kamala. I'm a practitioner in Kenya. I'd like to suggest that when the Kabuga trial chamber made an alternative suggestion, sort of like it wasn't a closed decision until the Court of Appeal said no, the appeal chamber said let's shut it out. It appeared to me that if the prosecution, Serge Bamerez and his team, had prosecuted Felician Kabuga's company, because that company allegedly imported machetes through Kenya, and those machetes were actually used. He dropped that thesis, and he was now moving on direct observation. But I'm suggesting here that the international crimes in that case might have been sustained by prosecuting the corporation, and we'd still have a trial. And the point was being raised in a way by Kate Gibson, who is saying, and also Professor Sungi, who is saying that the victims have lost out in getting justice. And that has happened because of the Nuremberg precedent, which says we want to individualize justice. But at Nuremberg, we also prosecuted corporations. And there must be a way that if the corporation was prosecuted, this case could still be sustained on an alternative basis without the human accused person. Thank you very much.
And I think at the Special Tribunal for Lebanon, there were 2 cases involving prosecutions of companies. Yes, okay, well, yes, Your Honor. Could we have the microphone to the front, please?
Thank you so much.
Oh. Yes, please. We'll come to you in a moment.
Yeah, thank you so much. I'm Dr. Philibert Gakwenzire, the president of IWOCA, which is an umbrella of Tutsi genocide organizations. I thank you so much in all. Today, we are dealing with the issues and the health of Kabuga. As we know, the crimes alleged to him today. We all know that what Kabuga is suspected to be. The question we have to ask ourselves is why we are in such a situation. It is simply because, among others, of course, that he took more than 2 decades and the land following his financial power, as somebody also said, and the panel. In all, we have to notice that states and the international community failed to arrest him in due time and take measures to prevent to become in the future when such a situation can present himself. Other measures that we have to take are related to possible consequences of today and tomorrow's Kabuga's situation in terms of denial. And we have to know that there are still other suspects that should declare having the health issues as him. So I can raise all consequences of Kabuga trial to victims, but we have to understand that victims, we are shocked by the situation. We are living because justice have to participate to the resilience that all Rwandans have taken to resolve. Thank you.
Thank you, sir. And Judge. Yes, please.
Thank you. I would like to thank the panelists for the discussion we've had this afternoon, and also Mr. Edward for leading the discussion. The issues that have been raised are very important. I'm not going to details of it, and for a good choice. But I just wanted to say that this afternoon and here, I've just learned that there are people who work together at the ICTR hearing you and reading some of the observation, the document we have had, and hearing Council Ms. Gibson for the reference she has made. So that tells us where we have come from. I just wanted to say the reference to that decision that you made the reference to was a trial chamber decision. And my own personal view is that we are dealing with serious issues across the world. So when you talk about regional representation, regional presence from all over the world is important. This morning, Under-Secretary General Mr. Ruto talked about knowledge. So when you have this kind of wide representation, you are actually, spreading this knowledge and the inputs in dealing with these situations across the world or to many parts of the world. So that has always been my personal belief. And as I say, that we have in chambers, we have people from all over the world. They do the work here, they create legal issues, including the judges, but also when they go back home, they are a firm representative of what they have done in this institution. So I just want to make that observation. Thank you very much for a very useful afternoon. Other matters I feel I cannot comment on, but I think the knowledge, those who gather the knowledge must be taken note of and see perhaps as we move forward, how do we go on for future endeavors in our work. Thank you very much.
Thank you, Judge Sekule. Yes, please, sir.
Good afternoon. My name is Yves Rosa. I'm a judge, a MIC judge. My question is related to CRPD convention. Like this. It's okay? Can you hear? Yes. Can you hear? Okay. My question is related to the CRPD convention. As you know, the CRPD convention is one of the international human rights conventions that it was designed to emphasize inclusion and participation within when it comes to the disabled people. This convention is almost universally ratified, and in the convention we see disability rights contextualized. So the convention doesn't create any new international human rights, just conceptualize the rights already existed in the other international instruments. Related to this topic, to the fitness, we see several articles in CRPD, such as Article 5, Equality and Non-Discrimination, Article 12, Equal Recognition before the law, Access to Justice in Article 13, and Article 14, Liberty and Safety of Persons. And related to this topic, at the United Nations, through the High Commissioner for Human Rights and the Special Rapporteur for the Rights of Persons with Disabilities, in particular, approved in 2020 some international principles and guidelines on access to justice for persons with disabilities, including the accused persons, which recommends the states to implement, to introduce amendments in their legal systems in order to accommodate the rights of people with disabilities, in particular with regard to access to justice. I like to mention the principles, and these guidelines have been endorsed by the International Commission of Jurists, the International Disability Alliance, and the United Nations Development Program. I just want to say what the CRPD committee says, clearly stated, declarations of a fitness to stand trial or incapacity to be found criminally responsible in criminal justice systems and detention for persons based on those declarations are contrary to Article 14 of the Convention, since this deprives the person of his or her rights to a process and safeguards that are applicable to every defendant. And in relation to this, CRPD says, requested from states to remove those declarations from criminal justice systems. So I would like to ask the panel. It's whether the international justice, in particular our court as a UN body, if we are bound or obliged to follow the CRPD Convention and the recommendations and the guidelines issued by its committee. Other question is keeping someone under jurisdiction indefinitely if it does not constitute a violation of his fundamental rights, or keep someone under custody without a trial indefinitely if also does not constitute a miscarriage of justice and a violation of his or her fundamental rights.
Yeah, thank you. I think Judge Bonomi sort of rhetorically dealt with that question, but I don't know, Professor Sungi, would you like to? No? Yeah. You sort of rhetorically answered that question during your presentation, but do you have one or two words to say? No?
If I understand the point that's being made by Judge Rosa, the human rights exist. The convention is simply declaring something that already existed. And he's making the point that it's the obligation of states to ensure that these rights are enforceable within their jurisdictions. I recognize that. But who must initiate the necessary remedies, another matter. And on that, I don't want to comment because that may turn out to be a live issue yet. If I've misunderstood you, I'm happy to chat about it again.
Well, in a moment, we're all going to be heading off to Lucky to the seat of the mechanism. So I think we're all going to have plenty of time to discuss these matters more informally amongst ourselves. I think if one thing has really shone through in the course of the last hour and a half, it's that these are all extraordinarily complex and difficult issues. These are difficult questions with no simple answer. And of course, if there were simple answers, there wouldn't be much point to this sort of colloquium. So I'd like to echo what Kate Gibson said. This is an important event. I'd like to add my thanks to the organizers. But I think most fundamentally, I'd like to ask you to join me in thanking your second panel.